Yes, Mr. Moser,
My lord,
you were.
I was
I
about...
think you were itching to draw the strands together.
I was itching to draw the strands together in the sense that I was going to respond to my learned friend's document and try to do it all in the same way.
Yeah. These are the propositions.
Propositions
Yeah.
that were produced.
Yeah.
And it's unsurprising, perhaps, in the way that I've alighted on Wolf, that I'd like to start with proposition 13, which is tucked away at the end.
Yes.
And causes of action. In a case involving multiple causes of action and so forth,
Yeah.
where there's judgment in favour of one and dismissed the other, then that's not merely upholding the judgment on other grounds. And that's Wolf in the case of an appealing defendant. The only change I would make, of course, and this would be unsurprising, is that I would say in the case involving multiple causes of action or separate issues, viz. Lady Justice Hale. Otherwise, I completely agree with the proposition 13. And I do say that there's a very clear line. It's not somehow an uncertain test. If one looks at the present example, there are essentially two relevant issues. Just briefly, if we could turn up page 69 of the hearing bundle, that is the annex to the judgment below, where the learned judge gives his answers to the list of issues.
So page
69 of the hearing bundle.
Yeah.
And we see there the various issues. There were a number, as my learned friend says. And over the page at 71, over 2 pages to 71, we see the relevant issues that we're talking about. They are respectively, if you see the heading by the first hole punch, schedule of manifest errors.
Yeah.
And there's only one issue on the manifest errors, although there was a schedule with a number of potential manifest errors, including the one on which we succeeded. So that's issue 19. Answer, yes, there was a breach. There was a manifest error.
Yeah.
Then there is another heading between the two hole punches, and the other heading is called relief. Relief. We've moved on from breach to relief, and at 23 is the outstanding issue. If there was, and there might have been, a material difference in the scoring of the bids, were the breaches sufficiently serious to justify an award of Frankovich damages? That is the issue on which we failed. Now, we say there is an obvious world of difference between putting in a respondent's notice in response to our appeal on issue 23 and to say in the respondent's notice, well, the judge was not only right for all the reasons he gave, he was also right for all of these other reasons which we put to him and which he ignored. That's a proper respondent's notice. And on the other hand, to put in a respondent's notice that attacks a completely separate issue, namely issue 19, and saying, oh, actually, you should never have reached the issue under appeal. The issue under appeal is sufficiently serious, which is predicated upon a finding of breach. Never mind all of that. We want to reopen breach itself. We want to reopen issue 19. And that is why, when one comes to it, looks at the respondent's notice, thinks about the structure of a procurement law case, it doesn't quite pass the smell test as a respondent's notice. Something is wrong here. They're trying to appeal that on which they failed below. I've already explained what I say, how actually it works particularly in my favour in the circumstances of the orders and so on. And I say, even if this had all been heard at the same time, even if there weren't an order that had left over the original appeal to the end of the show, even then, this is an attack on a separate issue. And in a Wolf way, therefore, the fact that the contention by the respondent is the judge was wrong to dismiss a distinct issue in the claim is an appeal and therefore requires permission under CPR. And really, that is a complete answer to all of these legal propositions. One could make certain points along the way, going back to the beginning. At 3, for instance, the mere fact that a respondent's notice may include the suggestion that the judge's findings of fact were wrong, that doesn't get you anywhere, as it's a statement of the obvious, but not in the sense that you can mount a separate attack, a root and branch attack on the decisive issue, and the issue that is not the one that is appealed against by the appellant. And that's something that should be very obvious when thinking about a test. So, well, what's the issue that's being appealed against? Is this an attack on another issue? And especially if one views it through the lens of B and paragraph 8 over the page, the things that are appealable, and I say in brackets, with permission appealable, we see at 8C2 that reference to NOGA at, I can't remember now whether it's the correct reference or not, but at 28B to C, to the issue on which the whole case ultimately turns. Well, actually, that is us, in the sense of a cross appeal. And I say that is quite an important lens through which to view it. Because we have appealed sufficiently serious. If we win on sufficiently serious, on our appeal, that's it, we're home. They need a cross appeal to say, if they win on sufficiently serious, even if they win, could win on sufficiently serious, actually, there was no breach at all. Once our appeal point is taken out of the picture, the issue on which the whole case ultimately turns is manifest error and breach. So quite understandably, they've decided, however tenuously they're able to do so, to attack the underlying breach, the manifest error, as a cross appeal to the appeal. And that's exactly what we see here. So you've got an appeal, it triggers a cross appeal, wouldn't otherwise be necessary. The cross appeal happens to be against another issue, against something that will only become relevant again if we succeed on the appeal. We fail on the appeal, it doesn't matter. We never have to worry about this. If we win on the appeal, this is the issue on which the whole case ultimately turns. It's a cross appeal, properly so called. It requires permission. And I have, of course, already said that as far as the order is concerned, the proper analysis of the order nowadays is a little bit different from the way it was at the time of Lake and Lake. If we look at Proposition 7 and the decision, when correctly analysed, means that you can only appeal against the order, I submit it's very different now after Wolf and after the CPR. And I venture to say Lake and Lake could be decided differently today, because now you look at what the order really means in the context of the case. You don't just look at the fact it says the case is dismissed. There has to be a little bit of judicial, not quite archaeology, then transparency in the sense of looking through the words on the page. And what must this mean? It's obvious what it means in this case. So I think really, rather than just going through and, as we used to say, denying seriatim at the points here made, it's clear where the lines are between us. And I say, in the way that, in fact, my Lady Justice Whipple already drew the strands together for me some time ago, therefore perhaps
Not nearly as elegantly as you're about to, I suspect. Mr. Wilson.
Not at all. I could probably have sat down some time ago and, as they say, missed several good opportunities to do so. Either when you're attacking a separate issue that goes to the root of the case, you need permission, because properly viewed, in a wolf sense, even a lake sense nowadays, properly viewed, you are attacking a separate issue. Or, in any event, it must be possible for the Court of Appeal to control its own procedures through CPR 1.1 in the same way, so that something that is in substance, either an appeal or that has no arguable prospect and is completely disproportionate, can be filtered out. Either or both of those, I say, are available to the court in this case and ought to be applied.
Yeah. Yeah, thank you very much. No, thank you very much, Mr. Moser. Ms. Morris, firstly, is there anything in reply on that issue?
If I may, my lord, I don't propose to be lengthy, but I would like to make one or two observations. The proposition that I understood was being advanced by Mr. Moser, with assistance from my lady, Mrs. Whipple, is as follows. And it is this: where a respondent's challenge goes to a separate issue, other than that upon which the appellant has based its appeal, then either it is a cross appeal or the Court of Appeal can treat it as such in accordance with the overriding objective. I just want to make one or two responses to that. First of all, if that is the proposition, then it is likely to lead to more appeals as a case proceeds, particularly in the current case management climate, where it's very common for there to be trials on separate issues. And there will be no incentive for a party which is unsuccessful at an initial stage to wait and see whether it wins or loses at the end, because this proposition will undermine the specialness of the defendant's position. Furthermore, it creates an uncertainty which did not previously exist. You can see from the bundle of authorities that this is not a problem that typically troubles parties or the court, and that's because it hasn't been necessary to draw a line, and this new line is in itself problematic. My learned friend has already touched upon the number of issues in this case. If you go back to the bundle, although it's nominally 23 issues, that is incorporating all the multitude of issues that were advanced in relation to manifest error. So it's 30 plus issues in this case. And it raises the question, what is a separate issue, particularly again in the current climate of case management, where people are encouraged to be very granular in their identification of issues. It's also troubling in our submission that what the learned friend proposes is going to require judicial archaeology of orders. And that ties in with a particular practical problem which would be confronted by those who might wish to bring a respondent's notice. Can I just invite your attention to the forms which appear in the bundle? The first is at 139. So these are the forms which a respondent completes, bearing in mind that a respondent's notice arises in all appeals. So if you have a look at the heading on page 139, section 4, details of the order or parts of order you want to appeal. So there's no invitation there to set out a finding, for example, as is being suggested by the learned friend, what the respondent is asked to do is set out the order, and then if you turn on to 142, what decision are you asking the appeal court to make? I'm asking to set aside, vary, new trial, additional orders, or upholds the order. Well, in this case, we say we couldn't have been anything other than the box that we ticked. And so if Mr. Moser is correct in his submission, then there's going to be some work to be done in the order department. In terms of his submissions as to what we did, and he took you to the order at page 76, paragraph 4, what we did was make clear that if we ultimately lost, then we would appeal. And of course, in those circumstances, we would be making an appeal on those grounds. But of course, if we won, there was nothing to appeal. And we say there was nothing agonised or problematic about that on the alternative. It was frank, and of course, it's consistent with proposition 10b in our list of propositions, because as the case law has made clear, the fact of winning has meaning, and that is what changed between June and the end of the year. We won, and that is why our grounds of appeal, there wasn't some dangerous alchemy that took place. We won, and that factor has for decades been addressed as significant. Now, Mr. Moser also relies on the Energy Solutions case as suggesting, well, you can always have your appeal running concurrently. That's true, but of course, that doesn't mean that one has to do it that way. And of course, in that case, as there are in a host of others, it created its own difficulties. Furthermore, his argument proceeds on an express assumption that a manifest error would necessarily lead to a different mark. And of course, that was an issue in the case. So it's not right to say that the finding of a manifest error was decisive or meaty in the way, in the language that he used. It was an issue. It wasn't a decisive issue because it still failed to be decided what that meant for the marking. Leave aside the question of sufficiently serious.
I thought the judge decided in the June decision that it should have been a 4, not a 3. Or have I missed that?
Yes, he did. But that was the question of, first of all, whether he should proceed to remark or treat it as a loss of a chance.
Right.
And then secondly, whether it would have made a difference, are separate issues, my lady. The point is that what my learned friend has submitted to you this morning is, once a manifest error has been found, end of. And what we say, if you look at the list of errors and look at the way the case proceeded, it wasn't as simple as that. And that's why you've got 30 plus issues in this case. And if one treats the word issue as used in the list of issues as meaning the same thing as the word issue when it's a separate issue in the formulation that my learned friend has adopted, that's a huge change in the position of a successful defendant. You know, where you've got, a multitude of issues and they go to that degree of specificity or granularity, it shuts out a successful defendant from a huge area. Finally, what Mr. Moser said to you after the shorter German was it was obvious that what we were doing was an impermissible attack. And of course, nothing was ever said until my Lord Justice Coulson raised the issue. And in my submission...
I have already apologised, so...
No, well, it's absolutely no criticism, and it's very important that we all get to grips. But it's certainly, in my submission, not obvious because it wasn't a difficulty for Mr. Moser or any of his predecessors until it was raised by my Lord. And therefore we say those sort of rhetorical devices are perhaps not as of greatest assistance. And finally, and I'm not sure whether it's still being advanced, we say, although the law of procurement is fascinating, wonderful, it's not special in the way that it might be suggested, or indeed that the issue of whether something's sufficiently serious is special in the way that it means that there might be some narrow framing of the rule only in the arena of procurement. That's all I have to say by way of reply.
Thank you very much. Just give me a minute. Thank you very much. Now, Ms Morris, we'll then consider the other points as you outlined, but it's probably fair to say this, that obviously this would proceed on the basis that you're wrong and that you do need permission. The question of the time and the question of the detail would obviously normally be dealt with by a single LJ on the papers. Now, we're not going to miss the opportunity of having you both here, so that if there are points that you want to make, we want to hear them. On the other hand, I'm conscious that we have already got possibly fuller submissions than we might have on an ordinary PTA. So none of that needs to be replicated. And so it's really only the killer points that either of you want to emphasise, or some point that may not be given any proper emphasis in your written documents that you want to draw to our attention. In other words, this ought to be relatively prompt, because I don't want to encourage the idea that, you know, oral PTAs are the way to go. I'll get into big trouble if that was the case.
I have got that all fully on board, and I can be very crisp.
Fine.
In terms of permission to appeal, the first criticism, if I can put it that way, that was advanced by my lord was, well, these are just factual based attacks. Response number one, there is a clearly articulated legal issue, namely, what approach should a judge who decides to remark take to the remarking exercise? And that is our ground 4. And briefly put, and I hope this isn't doing the judge too great an injustice, he said, well, they misunderstood the stair climber, stair lift issue. That went against the claimant, and therefore he would have got a higher mark. And what we say is that was the wrong approach, because it was a huge question focused on access. Access is broad and richly textured, and the question of whether a person in a wheelchair can get up and down the stairs was in no way decisive. And what the court should have done was go back and look at the entirety of the material. And we say it's clear that that's an issue, because my learned friend articulates a different approach, albeit relying on an authority which is addressed to a separate issue in the law of procurement. So I say that's a clear legal issue, and it's also one of general application, which is, you know, when judges decide to remark, how should they go about it?
And the authority is Wood that he relies on?
Yes, but my lord, if
and is that me?
I can't remember, but but the point is,
It's only because it rang a vague bell.
well, doubtless it does, but my lord,
But
the point
you say that goes to a different issue.
it's a different issue in the exercise. It's once a judge has said, I am going to remark, he's not engaged in a Wednesbury style exercise. He's in a I'm remarking the whole thing exercise, and it's wrong to focus solely on this micro issue in this panoply of wider issues in the question.
Okay, understand that.
Secondly, sorry, and if I could just say, attached to that are what we say, so although that's our ground 4, it's connected with what we say in ground 1 and ground 3, because ground 3 relates to the rejection of evidence that the markers said, if I had properly understood the stairlift stair climber position, that would not have led me to give a different mark. And we say, you know, classic JR territory, that would be material evidence, and that was set to one side. And also under ground 1, we raised this issue of, again, that would it have made a difference? So we say those are all connected with what is a legal issue and not a factual issue. In terms of the nature of our attacks on the findings of fact, and as my Lord entirely correctly says, we need to be in the territory of plainly wrong or no reasonable judge. If I can just give you one for example, one of the things the judge says is, well, all this stuff about prams and buggies was never mentioned at the time, and therefore it wasn't material. But having in fact, and we identify this in our grounds of appeal at paragraph 6, himself quoted the contemporaneous material which made exactly the same point. We say no reasonable judge who was able to keep in mind that in fact there was contemporaneous material would then go on to say several paragraphs later, no, there wasn't. So just to give you a flavour of the quality of our attacks on the facts. So I'm not going to go through it all, but I'm saying these are credible grounds, either legal or good quality fact-based grounds. Now, I can go through them all in greater detail, but I say this is enough to get me over the hurdle, bearing in mind the framework my Lord has asked me to put around my submission.
Well, we have got full written submissions, so it's anything else, as it were, really, that's not there, because you can rest assured that if we get that far, all of that will be carefully considered. Well, it has already been carefully considered, but there's obviously an opportunity, since you're here, for anything else, really.
There's nothing additional, just to ensure that the court understands the way in which they're framed, namely legal, and insofar as they're fact-based, we are well within that no reasonable judge territory. Turning then to the issue of the extension of time, in terms of the way that we proceeded, this defendant has been in no doubt since June that this is the case that we would be advancing. Sorry, this claimant, I do apologise. This claimant is in the same position they would have been because we made it entirely clear what we would be saying should we lose. It's right to say that we were sensible enough to extend time in the order in the way that we have, and although our respondent's notice was clearly within that, we didn't put in an alternative application. But of course, no one, until my Lord Justice Coulson suggested that we should do something different. So I think I've got to put my hands up and say we didn't put in that alternative application, but the substance is exactly the same. And we say it would be really quite unfair to penalise us where there's been no prejudice, and also where no one had suggested at any earlier point that we had got it wrong. Perhaps the other thing to say rhetorically is if we had applied in the alternative with a respondent's notice, addressing it on each basis, one wonders what the response of the court. No material impact on this claimant, this appellant.
Yeah. Yeah. Okay. Ingrid, anything?
Nothing else. Thank you very much.
No, thank you very much then, Ms Morris. Yes, Mr Moser, those are the two points, and the same for you. We've obviously seen your helpful written submissions on both of these aspects, so the real question is whether there's anything in addition that you want to draw our attention to.
Well, my lord, yes. I come first to the last point, which is extension of time.
Yeah.
And I combine it with a point made by my learned friend around how the rules are actually very clear at the moment, and we don't want to disturb the clarity that obtains. It is clear from the way that the orders and the exchanges with the judge unfolded on the other side that there was a certain lack of clarity or an uncertainty about the rules. Again, I make no criticism about that. It was no doubt the astute nature of the legal advice they were receiving that they were agonising over. Is this an appeal that requires permission? Does this all go into a respondent's notice? And right to the end, they kept the door open to seek permission. And we have said, in writing, it would have been prudent to do both, and I'm not going to add anything to that. So that's permission. As far as the grounds of appeal are concerned, assuming now that we're in permission on their grounds of appeal,
Yeah.
there has been already, albeit in a short contribution from my learned friend, a subtle reframing of the four grounds. Because what happened in writing is that we said, well, actually, the way you put your ground 4, which is that once the judge has decided that there is a manifest error, he should remark the whole thing himself. The way you put your ground 4 is arguably a point of law, but it's only a point of law because you've advanced a point of law that's completely wrong. They have seized on that bit in our skeleton argument to say, there's a point of law, and so this point of law is now doing a reverse takeover of all of grounds 1 to 3. But there are two things to say about that. The first is it's only a ground of law in the unarguable sense that I shall come to. And yes, my lord, it was you in Woods. But also, it is not one that extends to grounds 1 to 3. It really is confined to the question of what the judge ought to have done once he had found there was manifest error. There's no distinct point of law involved in grounds 1 to 3. They are suitably disguised, of course, apart from the Edwards and Bairstow point, which can't be disguised. They are points of fact masquerading as points of law. And when we're talking about fact, it's of course not just findings of primary fact. There is the reference in the footnote of our skeleton argument to that paragraph in is it Fage and Shabari. It applies not only to findings of primary fact, but also to the evaluation of those facts and to inferences to be drawn from them. And that's paragraph 114, very well known to this court. So if one looks at the judgment around the area that they're seeking to appeal, it's extraordinary to suggest that this is an area where it's going to be possible for the Court of Appeal to revisit the findings of the judge. If I can ask you very briefly to turn the judgment itself, because it's at hearing bundle 191. Sorry, that may be. No, that's their. Yes, can we start at hearing bundle 191? That's their skeleton argument. So, what they're actually challenging.
What's the paragraph number?
Paragraphs 47 and 48.
Thank you.
What they're actually challenging in ground 1, and I'll take A and B together, is the findings around the stair climb.
Mm-hmm.
And the first challenge is, well, you didn't have to fill in the gaps. You didn't understand what a stair climb was. And the second is, well, you ought to have known. And that somehow the appellant had already abandoned a suggestion of a duty to investigate what a stair climb was. Well, I take those in turn. If one looks at the judgment, and that's paragraphs 130 and following of the judgment, starting at page 59 of the bundle. So page 59 of the bundle, 130. Well, actually, let's start at 129, because there were two aspects that were misunderstood, two crucial mistakes made by the defendant. And they both related to access to the first floor premises. One is about the stair climb, and the other is about a misunderstanding that there was some inferior alternative premises. So the first aspect is at 130, the use of a stair climb. Now, stair climb is an ordinary word. The judge found that there was no duty to clarify because the bid was clear. A moment's search of the website that was identified in the quotation, we see that 4 lines down, would have revealed what a stair climber was if you were in any doubt as to what a stair climber is. This is just about the ordinary understanding of words by people who are evaluators, and indeed, especially if you're experienced in disability in the NHS, as these evaluators were. And if you're reading a tender and you come across a word you don't know, perhaps not everybody knows what orthodontics means. Well, you then find out what it means. is a common sense finding by the judge. It would have taken a matter of moments to establish the claimant was not proposing a fixed stair lift at all. And that's not a Thameside duty, that's not a regulations duty for clarification, seeking clarification under the procurement provisions. That is just reading and understanding. It's comprehension, essentially. And if one turns over the page, then the next bit of paragraph 130, we will see the witness accepted. Miss Fangarack-Jones accepted it was an error to have interpreted the proposed item as a fixed stair. Its written skeleton argument, the defendant accepted an incorrect assumption had been made. We'll see in paragraph 137, it was equally accepted by the other witness, Ms. Easterby Smith, that in retrospect it was harsh to have criticised the adequacy of the claimant's premises, alternative premises, because they were only being considered on the mistaken assumption that that they were being offered as premises in relation to getting up the stairs. And we see that at paragraph 131. In respect to the second point, business continuity. If our existing site became inaccessible flood fire, we can temporarily relocate. And somehow, in a way that nobody could adequately explain, they thought that meant they would be routinely available for disabled patients. And those were admitted, straightforward errors. The judge's evaluation and inference from that really cannot be faulted. And as for this myth that we somehow conceded that this was not an appropriate approach, that is said to be based on paragraph 33 of this judgment. That's at page 42 of the bundle. That was about a different thing. That was about a duty to investigate that had been pleaded in relation to PAL. That was the other bidder. And that was abandoned by my learned friend, Mr. Paul Allen. It's got nothing to do with the fact that the judge later found it was a common sense thing for the evaluators reading our to try and understand it properly, and they should have understood it properly. Not something that we've somehow abandoned in relation to our bid or at all. All of these matters, including, finally, the conclusion that the stair climber would be used by others, not just those in wheelchairs, and that's the conclusion at 139, based on the evidence before him, are evidential points that were perfectly open to him to find. If we look at 139 on page 61 of the judgment, about halfway down, when asked if a stair climber could be used by non-wheelchair users, Mr. Spathula said, "I think so. I'm not aware of any reason why not." Well, that was accepted, for instance, in relation to a person with a broken leg. The judge says, "Doing the best I can, I conclude a stair climber could be used by a patient with limited mobility who was not in a wheelchair." And it really is that the sort of issue that this court is to be asked to adjudicate upon afresh? I submit clearly not. And as for the idea about the buggies, we've already pointed out in writing, that's a category error. A category error. My learned friend says, well, buggies were mentioned in the underlying documentation. In fact, it was prams. We see that at paragraph 134, the last sentence. A proposal to install a stair lift is not really adequate. Of course, she's misunderstood that. This is not only about wheelchair users, but people with reduced mobility and pram access. And then at 140 is the non sequitur, according to my learned friend. At 61, Ms. Fangarack-Jones also made a separate point about parents with buggies and prams, which notably was also not specifically mentioned in the contemporaneous documents. Quite right, parents were not mentioned in the contemporaneous documents. And the judge says it may have been an afterthought. Well, it may not have been an afterthought. Plainly not part of his ratio that it was an afterthought. He goes on to say, she said many younger or teenage patients were likely to be accompanied by parents with buggies and prams for their siblings. Well, that was certainly not in the underlying documentation. And then the judge finds quite reasonably, first floor premises could create a difficulty for them, but as the claimant submitted, that is caused by the existence of the stairs, not a difficulty limited to parents with disabled children attending as patients. The principal focus on accessibility under the Act is on the patient. And my learned friend now says, yes, but the Equality Act includes age, presumably meaning babies, and it includes maternity, presumably meaning pushing a pram. That's in the grounds of appeal, paragraph 18. Well, but that was not in the contemplation of the evaluators at all. So that is definitely a new point, and indeed now used to try and shoehorn this into a point of law, and so on. And I've already made in writing the point around how the judge said that he took all of the evidence into account, and that is not something that is to be gone behind. So I won't make that point again. And that takes one finally to this point around ground 4. And ground 4, if we can just turn briefly to the skeleton argument. Ground 4, first of all, grounds in this idea that he didn't take all of the evidence into account, and that's at page 147 of the bundle. Sorry, that's the beginning of it. It's page 192 of the bundle, forgive me.
Yeah.
192, so that's their skeleton argument, ground 4. A legal issue about whether in rescoring, trial judge was correct in attempting to reconstruct what these evaluators would have scored, but for their error, taking the narrow approach of adopting the unimpeached aspects of the original reasoning. And the respondent submits, as a matter of law, the correct approach, which should have been taken, is for the judge to rescore the question afresh, having regard to all the evidence. So what we said about that is first of all, there's nothing in this anyway. He took all of the evidence into account and he said so. That's in paragraph 147 of the judgment. And we've made reference to Henderson, paragraph 48. Now the Court of Appeal is to assume, anyway, that that's what the judge has done, even if he hadn't said so. But secondly, we say, well, this would be the only point that arguably touches on a point of law. However, only because the point of law that it advances is entirely contrary to authority. And that's where we've referred to Woods. That's the last point I plan to make on these grounds. But if we look at Woods in the Authorities Bundle 6, at page 120, and this is my Lord Justice Coulson, at paragraph 12, the first and still best known case in which a judge worked through a tender to see whether or not manifest errors had been made was Letting. There, Silver J followed the approach of Morgan J, line apparel, and went on to say that I agree with Mr. Anderson, it is not my task merely to embark on a remarking exercise, to substitute my own view, but to ascertain if there's a manifest error, and so on. And then fourth, the issue for me is to determine if the combination of manifest errors made by Newell in marking the tenders would have led to a different result. And I submit it's perfectly clear that the one thing that judges ought not to be invited to do is what my learned friend suggests, which is that you then go on and mark the whole thing afresh. We see what the learned judge did in the present case, and I submit that is entirely correct. And if we look for the last time at the judgment itself, hearing bundle paragraph, page 67. Page 67. This is what the judge in fact did at 85 and 86. Issue 20 is the question of whether the court should attempt to rescore the bids. The defendant accepts that if manifest error is made out, the court will normally rescore unless it is not possible to make a reliable assessment of material error. And over the page at 68, 187, in respect of issue 20, I decide the court can rescore the bids, and it would not be appropriate to assess the position on the basis of loss of a chance. Forgive me, I should have probably started with, I'm sorry, I'm trying to do it too quickly.
Yeah.
With the findings at page 63, and that's at 147. And here we have both of what I've trailed several times now, just by the first whole punch. The judge, having regard to the totality of the evidence relevant to CDSO2, I'm satisfied the overall score would have been different to the one given.
Yeah.
Before
Well,
the
that was the
exercise-
passage you referred to before.
Yes.
You didn't take us to it, but I've marked it up anyway. That was the passage you referred to where you said the judge did take into account.
It did take it all into account, but also his approach to remarking is unimpeachable, because he asks himself what would have happened absent the manifest error. He doesn't sit down and look again at all of the evidence, in particular in this case, where the documentary evidence indicated that the one issue on which they were marked down by the point was the issue of accessibility and the alternative accommodation. Once that fell away, as the judge says, there was nothing left. And so, again, rather like the issue on witness credibility, which is completely out with the ambit of an appeal, this is an area where the judge's approach can't be criticised. I haven't gone back over all the points we made in writing.
No. Well, there's no point because we've got
Those were the main ones.
Yeah.
And finally, may I abuse my reply in one more way, which is when my learned friend said earlier that my approach would lead to more appeals. But of course, it wouldn't, in my respectful submission, because if, like in this case, all of the appeals, including permission, were left over until the end, no appeal would be necessary unless it came to cross-appeal on the point of respondent's notice. That's the beauty of the arrangement. The fair cross-appeal is only triggered if it becomes necessary by reason of our appeal. And so I take issue with the idea that this leads to more appeals. I say it may lead to fewer.
But you do say, don't you, that it's an appealable point the moment you have, I can't quite remember the phrase that you used, actually, the Baroness
issue.
Hale prose, a separate issue.
Yes.
The moment you have a separate issue, then you've got an appealable point, you say.
Yes.
It doesn't matter if it's in the order or not, because you just need to understand what's happened as a matter of substance. I think that was the point that was being made against you by Miss Morris, is that potentially that means you might have a multiplicity of appeals coming in. You might then stay them or say, I don't want to proceed with it until I know what's going to happen at the end of the day. But conceptually, I think you do open the door, don't you, to more appeals?
But that's already the case, though, because we already had the separate issue, say, as we went along here, as they did in Energy Solutions. So then it's a question of case management, of whether you say we'll appeal now, or we leave it over, as we did in this case, to the end.
Well, Miss Morris says it isn't a case management point because you don't have an appealable point until you know who's won or lost, and then she comes in. So I think it does actually, as a matter of sort of structure, make quite a difference. The two cases that came.
Well, of course we differ on that, because I say she did have an appealable point
I know you do. Yeah.
in June, just didn't pursue it then, and I make no criticism
Quite.
of that.
Quite. But just to pick you up, I think I'm just coming back on the there won't be any more appeals.
No,
And
right.
I just struggle with that a little bit on your analysis, because there will be lots more circumstances where there are appealable points to be taken. And you say it's there already. You say it is.
I
It
do.
is. Yeah, understand.
Unless there's anything further.
No, that's very helpful. Thank you very much. Ms. Morris, is there anything to reply on the PTA, I'll call it?
Oh, my lord, yes, obviously there's a huge amount with which I might reply. The difficulty is the circumstances where this is meant to be a question of permission,
Yeah.
and B, within
It is a
within
question.
that,
It is a question of permission. It's not meant to be. It is a question of
but
permission.
also even within that, you've asked me to be brief, and I think perhaps my learned friend indulged himself a little bit more than I did. My lord, I can go back on all of those points, but then we're getting into the guts of the appeal. It's hugely problematic. If I can, for example, pick up one issue which is being made, which is where Ms. Falgarak-Jones in the contemporaneous document said, whatever it is that's getting people up and down the stairs, it's not addressing the access issues which are not related to being in a wheelchair. That is a gritty and real point for the NHS when it is seeking to secure access to services, and it is not any stretch to suggest that if you have a teenager who is entitled to orthodontic treatment, that teenager is going to be brought probably by their mother, society being the way that it is, and that mother may well have other children who are in buggies. And to suggest that there is some straining of language and law to read what Ms. Falgarak-Jones said, this doesn't deal with someone in a pram, we say is doesn't do justice to either reality or the legislation. And that is why we say that we are in the territory of no reasonable judge in relation to that ground. And then secondly, we do say that that is a real question of law, whether or not a judge should approach rescoring in the way that he did. And again, the nub of that issue is that this question was a broad one about access, and I can take you back to it, but it's about, are you near public transport? Is there going, where are you located in relation to the region? And the point is where the only error was in relation to, is this a stair lift or a stair climber? There is a real question about whether the appropriate thing to do is make a whole mark rest on that, which is what the judge did. And now, as you can imagine, there's quite a lot to say. That's why we've got 4 grounds of appeal, which we're asking this court to entertain. And we would say they are non-trivial. We do have a reasonable prospect of success, and they are also points of general public interest insofar as they engage questions of how the court ought to deal with issues such as access under the Equality Act and the approach in procurement. But obviously I don't need to go that far, but if I'm allowed to proceed on the basis of respondent's notice, but if I say I'm compelled to ask for permission, then these are substantial grounds which we should be permitted to advance.
Well, the real prospect of success is the focus. If it's an ordinary PTA, I mean, the wider point of principle probably only arises if the real prospect of success looks a bit wobbly.
Well,
because it's not a second appeal, so whilst wider points of principle are a perfectly legitimate ground of appeal, certainly speaking for myself, I tend to look at those second, because I'm not suggesting that it's the case here, but you will understand that in practice it is often a make-weight. Because it's not necessary if you have a real prospect of success.
That's absolutely true. They are not; those points are not made on my part, though, as make-weight points, my lord. Particularly where, as Mr. Moser has explained, and perhaps it won't have escaped my lord's attention, this case is within at least the realm of procurement, a high-profile one, and the question of how a judge ought to approach the remarking exercise after a finding of manifest error is one which I would say was of wider significance in this realm. This isn't just any old procurement case.
It is of wider importance. It's not just any old procurement point.
Well, my lord, because...
But
sorry.
it still can be advanced without permission because it's not on your submission an appeal against the order. I mean, there is a tension.
Well,
I mean, I completely understand all the submissions that both parties have made all day. There is, I don't know what the answer is, but there is, I'm ending where I started. There is a tension between, if you're right, this is a point of wider importance, is high profile. How do you rescore? How does a judge rescore? But on one view, it's not the focus of the appeal. But it would be if Mr. Moser was right about the Frankovich point.
gosh, that's such a multi-clause sentence,
Sorry.
my lord. I'm struggling to keep up.
Sorry. It's not the focus of his appeal, obviously, because his appeal is about something completely different, sufficiently serious. But if he's right about that, and assume that the court, when dealing with the substantive point, deals with that point first, then you then stand up, roll your sleeves up, clear your throat, and you're in on this point of wider importance about how a judge rescores.
Well, my lord, I'm not sure that that will be the order in which the court tackled it, although that might be a question for another day.
Well, I was thinking exactly the same. I mean, again, I'm not sure that necessarily makes the position much clearer. You would say, actually, logically, that came first.
Well, my lord,
The respondent's notice comes first.
Well, my lord, let's see what the sorry, I mean, my lord, you can see that the twists and turns of this, you know, make the I don't know. There's probably a literary allusion there, which I'm not going to struggle to make. But this has been a labyrinthine case, and you can see it started off with 30 plus issues. So in one sense, we're doing quite well, having whittled it down to however many we're left with now. But my lord, I would venture to suggest that case managing this appeal might make sense simply to identify what the issues in the appeal are. And allow for those to be argued in effectively a sort of logical order. That's certainly what would appear to me to be sensible, even if how each point is advanced means it's from a different perspective.
Yeah. Okay. Well, as I say, I'm slightly teasing, but I'm ending where I started, which is, as I say, I'm going to have to consider we're all going to have to consider your submissions, both of your submissions, very carefully. And the answer is not, to me at any rate, obvious. But I do think that at the moment, at any rate, I might have been right to identify it as a point that needed to be clarified. And I take your point that although Mr. Moser quite rightly is focusing on his case, in this case, which is obviously a procurement dispute, it doesn't, at the moment, seem to me to be something that, when we come to consider it, we should be just narrowly looking at that. So I take that submission. Okay, all right. Yes, thank you very much. Well, as advertised, we're not going to be handing down our judgments this afternoon. We will consider the submissions very carefully, and you will get our draft judgments in the fullness of time. We will obviously endeavour to do them so you have them before the end of term, but I'm not promising that, because we are now getting to the stage where that becomes an issue, but that would be our plan. We would send out the drafts to you as drafts. That's for you to check the typos and any obvious factual errors. It is not an opportunity to re-argue the case, and so that is not to be done. You will get the drafts, and the people who will get the drafts will be those identified to my clerk I'm not sure that he has yet taken the relevant email addresses, so perhaps the parties could provide those. Oh, he has.
Oh, yeah, we
Oh,
have,
good.
thank you.
Fine. Okay. Well, thank you very much for that. So the draft will only go to those names for whom email addresses have been supplied. As you both know, but as I make clear, there are now much stricter rules around the provision of the draft, particularly if this is, as we are told, a high-profile case. Those rules, even more so, must be complied with, and as you know, that there are grievous penalties for not complying. I don't think there's anything else, and I'm not sure, this appeal has not yet been listed, but that can then take place once we've handed down our judgment. It would be helpful, once we've handed down our judgments, for the parties to indicate how long they think the appeal will take. There's no point doing that now, because the answer would be, well, it depends on whether you allow the appeal or not. But once you know the answer to that, it would be very helpful so that we can properly list it. And there may be a prospect of getting it on next term in Michaelmas, provided it's not too long an estimate. Right, thank you very much. Thank you to your teams behind you. We'll let you know.
All right.